The Answer.
Get the latest weather, traffic, and news updates online at 560theanswer.com. Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft on AM 560. The Answer.
Top of the morning, Dan Proft here. So, the Birthright Citizenship case before the Supreme Court. Oral arguments yesterday. And fresh off of her dizzying performance in the Colorado conversion therapy case, KBJ tried to tackle the subject to the jurisdiction thereof determination. You know, that so much of this case turns on what is subject to the jurisdiction thereof in the 14th Amendment. What does that implicate? And here's a little hypothetical she offered to try to illustrate what she thought that phrase meant.
I was thinking about this, and I think there are various sources that say this, that you obviously have permanent allegiance based on being born in whatever country you're from. That's what everybody recognizes. But you also have local allegiance when you are on the soil of this other sovereign. And I was thinking, I, a U.S. citizen, am visiting Japan. And what it means is that, if I steal someone's wallet in Japan, the Japanese authorities can arrest me and prosecute me. It's allegiance, meaning can they control you as a matter of law. I can also rely on them if my wallet is stolen to, under Japanese law, go and prosecute the person who has stolen it. So there's this relationship based on, even though I'm a temporary traveler, I'm just on vacation in Japan, I'm still locally owing allegiance in that sense.
So, subject to the jurisdiction of turns on allegiance, which turns on domicile. So her argument is, my wallet is stolen I'm in Japan, and my wallet is stolen there. The authorities step in to find my wallet, and thus I have an allegiant relationship with the Japanese government. Oh, boy. Okay, so by that logic, and I use that term loosely in this case, then anybody who travels to the United States for any length of time has established the requisite allegiance to be a citizen of the United States. Student visa, tourist visa, work visa. The only thing that would preempt anybody from establishing themselves as a citizen of the United States would be the denial of visas. And frankly, this is an argument for birthright citizenship for people here illegally. So even if you could get here illegally, or even when you do get here illegally and then you have kids, then they are citizens as well. So whether you get here legally or illegally, you are subject to the jurisdiction thereof, subject to the American government's jurisdiction thereof, and therefore you can claim a citizenship right. Interesting argument. The Solicitor General John Sauer and KBJ, after that foray, got into Wong Kim Ark case, one of the cases that the pro-birthright citizenship crowd is relying on. And this whole issue of domicile and how you determine intent to stay. Domicile, allegiance, subject to the jurisdiction thereof.
You say prospective, we're supposed to do this. Don't worry about the people who are already here and who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, Social Security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get a...
No, not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So are we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity. There's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases, is directly addressed in that guidance.
After the fact.
Yes.
After their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I'm summarizing because I'm not an expert in computers, but there's a computer program that currently automatically generates a Social Security number. SSA says, look, a Social Security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a Social Security number, provided that the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Thank you.
Yeah, it's just such a bureaucratic nightmare. Make them all citizens. Is that what you think, KBJ? It's a process. How does this happen? How do we establish that somebody, a woman, I know that's a confusing term for KBJ, when a woman gives birth, how do we know that child is going to be conferred citizenship? Well, because we know the legal status of the parent. And then you have the process of the conference of a Social Security number and so forth. Yeah. A counterexample that was offered by Alito to the ACLU's lawyer, Cecilia Wong, I think nicely provides the actual illustration of the folly of the position that Kagan and KBJ was taking with respect to subject to the jurisdiction of, which turns on allegiance, which turns on domicile. And by the way, that all follows the parent for the purpose of the child.
Not subject to any foreign power is pretty straightforward. So let me give you these examples. A boy is born here to an Iranian father who has entered the country illegally. That boy is automatically an Iranian national at birth, and he has a duty to provide military service to the Iranian government. Is he not subject to any foreign power?
Not within the meaning of the 1866 Act, Justice Alito. And that's clear from Wong Kim Ark, and it's clear from the debates. What the framers meant by the phrase not subject to any foreign power was referring to the ambassador exception. If it meant what the government contends, basically not a subject of any foreign power, that another country considers you a jus sanguinis citizen, then lawful permanent residents, all foreign nationals.
Well, ordinary public meaning of that would certainly encompass that boy, would it not?
Justice Alito, if you think that the language of the 1866 Act was ambiguous, as Wong Kim Ark says, the shift to the language of the 14th Amendment, which is the operative text, certainly clears up any ambiguity.
What I said about a boy born to an Iranian father is true of children born here to parents who are nationals of other countries. If I'm correct, it's true to a child who's born here to Russian parents. It's true to a child who's born here to Mexican parents. They're automatically citizens or nationals of those countries and have a duty of military service. It sure seems like that makes them subject to a foreign power.
But again, Justice Alito, that would have meant that the children of Irish, Italian, and other immigrants, which Wong Kim Ark refers to and the framers refer to, would not have been citizens either. Because if the only test is whether that U.S.-born child is considered a citizen by another country under their jus sanguinis laws, then no foreign nationals' children would be.
Well, in all of those cases, the parents could be naturalized, and then the children would be derivatively naturalized when the parents were naturalized.
Yeah, the difference is that those individuals you're referencing, Ms. Wong, came through Ellis Island legally. That's a big difference, too, which I think is what Alito is getting to. For more on all of this, pleased to be joined by Professor Richard Epstein, James Parker Hall, Distinguished Service Professor, Emeritus of Law, and Senior Lecturer at the University of Chicago. Professor Epstein, thanks for joining us. Appreciate it.
Oh, yes, well, it was painful to listen to the oral argument.
What, particularly Ketanji Brown Jackson, but not limited to her. Take up the wallet example if you have anything to add to it. So she goes to Japan. Yeah. Her wallet gets stolen. The Japanese police help her find it. Therefore, she has a temporary allegiance to the Japanese government, and she's subject to their jurisdiction thereof.
They don't understand the law. What happens is there are many different elements of these cases, but the first thing to note is a lot of the questions are actually answered if you look at the Naturalization Act, which were put into place in 1790 and continued in the original form, basically with some modifications, key ones, through 1870, when for the first time persons of African descent were allowed to apply for citizenship. And one of the requirements of becoming a citizen of the United States under the naturalization statute added in 1795 was that you renounce all loyalties to some other jurisdiction. Another requirement that was made very clear in the Naturalization Acts of 1790 thereafter is the status of any minor child is determined by the status of the parent. So if the parent gains citizens, the minor child automatically gets it. If the parent doesn't gain citizenship, then the child cannot get it under the statute. And so when Ketanji Jackson starts to ask, well, the 14th Amendment doesn't make any reference to parents, what happens is you don't need to make a reference in that because you have the references made in the 1790 Act. Now, why does that matter? Well, the text is all persons born or naturalized, and so it would be therefore appropriate to look at what the naturalization statutes say and how we start to deal with the problem. And neither side wanted to address those statutes at all, and there was a kind of a reason why they both wanted to shy away from it, because these statutes are not pretty. The first word in the 1790 Act, which remains operative through 1870, was all free white persons may apply. So there was an explicit color bar that was built into the statute. And there were also other rules which essentially said when they did the 14th Amendment, we're trying to make people citizens, but we're not trying to give them the vote. So essentially, the founders of the 14th Amendment, contrary to modern expectations, were basically segregationists on a large number of systematic issues. And if you start looking at the statutes, then what happens is you go back to Blackstone, there's a key distinction made there over and over again between being within the jurisdiction, which is the language that you see in the 14th Amendment in connection with equal protection but not due process, and subject to the jurisdiction. And these phrases are not treated as synonyms, they're treated as direct opposites. Being within the jurisdiction meant that you had local jurisdiction over you, so you were necessarily obliged to follow their traffic laws, their criminal laws, and all that stuff. But as Blackstone said, the moment you left, all allegiance to that country would simply disappear. And local citizenship or jurisdiction was never thought to be a path to citizenship anywhere throughout the entire civilized world. What happens is this rule turns out to be completely uniform because there's no nation whatsoever that basically want to say that people can come in and do whatever they want. And if you want to make sure that they don't come in, the rule has always been established that the naturalization power means you don't have to make them citizens what you want. And in addition, what happens is not by the Constitution, but by a judicial fiat, you also saw that the federal government assumed power over immigration, which was not part of the original constitutional design, but was grafted on by the cases that were decided under the Chinese Exclusion Act. Within the jurisdiction, therefore, does not mean the same thing as subject to the jurisdiction, which is why one phrase is used in the due process clause that applies to all persons, and the other phrase is used with respect to describing the citizenship clause. And when the cases say that the two phrases mean the same thing, as some lower court judges have said, they're just making up history in a way that's utterly indefensible.
Well, yeah,
So
I mean,
the answer to all.
Go ahead.
Go ahead. The point is, domicile was no part of the original Constitution. If you go back and look at the statutory text, it's not there. Domicile gets introduced only in Wong Kim Ark because they're trying to play a fiddle around the general problems of the Naturalization Act, because in 1898, when that case was decided, no person of Asian descent was eligible for naturalization. There's a total bar on that, and it didn't get completely lifted until 1943. And so if you applied the Naturalization Act, the fact that they were a citizen of China and they were traveling on a Chinese passport would end the case, and there would be no citizenship whatsoever. Now, none of these guys wanted to actually look at the statute. I don't think anybody mentioned the Naturalization Act. When they started to talk about the English tradition, they got everything 100% wrong. But if you take the correct reading, the domicile issue just drops out of the case. Go back and look at the Naturalization Act, and it turns out that that statute gives the Congress plenary power to decide what the rules were.
Well,
the original rules in the statute.
So then when Sauer, when Sauer essentially said, subject to the jurisdiction thereof, so it means allegiance, and how you determine allegiance through the domicile status. What was he trying to do there?
Well, look, I mean, you have to understand there was a strategic move that they made. And as you know, I wrote a brief in that case which said everything the opposite. And I've got a book that's coming out soon which talks about this in excruciating difficulty. What he did not want to do in that case was to take on the original Naturalization Act because of its obvious racist implications. Yeah. And he found that just very difficult to talk about. And so what he does is he says, look, I'm going to accept Wong Kim Ark, even though, as I've told you, it's just 100% wrong on the actual text. And I'm going to win two ways. He says, first of all, he has to be a permanent guy. And all these birthright people come for tourism. They're just temporary. So permanent and temporary don't mean the same thing, and I win. And then also, if you look at Wong Kim Ark, there's not a single mention of illegal entry into the United States. And so therefore, he says, all people who are illegal aliens don't come in under Wong Kim Ark. So we went under the case without going back to the Naturalization Act. But in fact, the problem that you had is the naturalization statutes, even if you put aside the Chinese exception, has this problem about essentially renouncing former sovereigns, which you don't do when you're carrying a passport. And it also requires essentially that you swear allegiance to the United States and go through various processes. Well, they just want to avoid that. Now, just to make it worse, since nobody talked about the Naturalization Act, what happened is Justice Kagan wrote an illiterate history that's completely incorrect about the incorporation of the English law into American law. The first thing to understand is they did incorporate the rules about being in the jurisdiction so you could control the traffic stuff. But in fact, as they noted, the English laws were statutory. They were not common law. And when we passed our Naturalization Act, that act controlled the English stuff, and it was a complete different approach because we had the problem of slavery and black admissions, which we did not want to face by allowing people to come in.
Well,
and
so then
under those statutes,
go ahead.
So what happens under those statutes, you get a bifurcation in the United States. It is very clear that all federal jurisdiction on naturalization is decided as a matter of federal law. That's the only thing that Hamilton said about the naturalization power in the Federalist Paper, and he was clearly right. What happens is most of the cases that are decided in the United States before the war are cases decided under state law, which have no relevance to the federal issue and can be decided any way in which they want. And those cases were decided for all sorts of reasons, that whether or not somebody was entitled to vote, whether or not they remained a citizen so that they could make gifts and so forth within the law of the state. But not one of those cases actually deals with the federal preemption statute. So when you start looking at that, go ahead.
So when Amy Coney Barrett started this line of inquiry, and KBJ sort of ham-handedly tried to pick it up, of the intent to domicile, what was ACB trying to do there?
Well, what she's trying to do is to figure out whether or not, when you have people with short-term residences, you use a domiciliary test to see whether or not they get in, because what she never wanted to do is to look back to the naturalization statutes. And you go back and read those statutes, domicile is not there. It's only in Wong Kim Ark. So everybody is playing off of something which was not statutory. And, why do you ignore the naturalization statute? Well, when I first looked at this stuff, it said every person born and naturalized. I never actually read the naturalization statute. When I opened it up and started to read it, it was an absolute mind-blowing experience. And so what happens under those statutes, in 1866, no black is eligible for citizenship. Everybody who gets citizenship as a child gets it through its parent. And so that was well established. So when Kajanzi Jackson asked, well, why don't they mention children, parents in the amendment? They didn't have to do it because it was all taken care of in the Naturalization Act. So it's a complete bowdlerization of the statute. And then when it comes to the English stuff, their rule about, living in the state as born makes you a citizen was completely rejected in the United States. And when you start saying the English common law carried over, there are 100 cases under the Naturalization Act which show that we did not follow the English rule. But even if I stipulate to what you're saying about the naturalization laws, doesn't Sauer and by extension Trump win either way? Because if you look at the legislative history of the 1866 Civil Rights Act, and how it informed the 14th Amendment, isn't it clear what subject to the jurisdiction thereof meant, such that if you are here illegally, then there was never the intent to provide citizenship for your child? Yes. If you look at the text, it's pretty clear. By the way, the phrase subject to the jurisdiction also appears in the 13th Amendment, and it doesn't mean within the United States physically. What they wanted to say is if you are outside the physical borders of the United States and you still owe disloyalty and was a citizen, then any slave that you owned the slavery would have to be abolished. And so subject to the jurisdiction meant loyalty to the United States. And the thing to understand, the deal was only this: we give you protection and you give us loyalty. Voting was no part of anything that was associated with citizenship at the time, which is why you needed the 19th Amendment, I guess it was, to give women the vote in 1919. Right. So what happens, you can't write a history of this without actually knowing the statutory law. Let me give you another example, just a silly statement by the Chief Justice. What he said was, the Constitution's the same, even if the social situations were different. But if you had looked at the 1870 Act, the first 6 provisions are efforts of the government to tighten immigration into the United States because of the fear of being overrun by foreigners. And it was an exhaustive increase of the requirements you needed because the federal government had plenary power over naturalization. So what his mistake was, it was the same Constitution, to be sure, but he got the early Constitution wrong because he never read the statutes. I mean, this is absolutely critical when you do constitutional law, is that you not only read one or two snippets, 1 or 2 cases, you have to go back to the entire history. And none of them bothered to do it.
Maybe the entire court needs you to be like a clerk at large.
Well, I'm happy. I wrote a brief.
I know you did. And
nobody mentioned it. I mean, it's not a trivial point.
Richard,
Mark was wrong. Yeah.
Yeah, Richard Epstein, we're out of time, but appreciate it. James Parker Hall, Distinguished Service Professor, Emeritus of Law, Senior Lecturer, University of Chicago. Professor Epstein, thank you as always. Appreciate it.
To be here. Bye-bye.
Take care. And he joined us on Chicago's Morning Answer.
It's news, opinion, and insight at the speed of your life. Streaming at 560theanswer.com on the AM 560 mobile app, or tell your smart speaker to play the